H1B to green card. You have an H1B visa, it's good for 3 years and you're able to renew it for an additional 3 years. How do you get the green card once you have the H1B status? The first step in the process is to file an application called PERM, which stands for Program Electronic Review Management. It's also commonly referred to as a labor certification. The PERM has several steps to it, and again, this application is filed with the Department of Labor. The first step requires you to get what's called a prevailing wage determination from the Department of Labor. That determination tells you the minimum salary that the employee is required to be paid by the employer. So it might come back and say that the employer is required to pay the employee $50,000 or $100,000, whatever the determination is. The employer is required to pay that amount at a minimum. You can always pay more than that amount, but you have to meet that minimum amount set by the Department of Labor. Regardless of what you think you want to pay, you have to pay that minimum. The next step is you have to advertise the position in various locations. For example, typically you would advertise them in Sunday newspapers, you would do a job posting at the work site, and you would also have to run advertisements through the State Workforce Authority at the local Department of Labor. In addition, there are 10 other locations that you could potentially advertise the position, and you have to pick 3 of those 10 to advertise. So it might be something like an online advertisement, a radio advertisement, television advertisement, etc. There's a list from the Department of Labor, and you get to pick which other 3 you want to advertise in. After those advertisements are run, then what happens is there's a 30-day quiet period, and what that means is the employer has to wait 30 days to see if there are any qualified U.S. workers who apply for the job and actually want the job. So the potential candidate could apply for the job and then decide later that they don't want to actually take the job. If both things happen, they're qualified and they want the job, then the application would not be successful and you would have to look at potentially hiring this new person that applied or just scrapping the whole application altogether. But let's say that the PERM application did go through, that no qualified workers applied, then the next thing that would happen is that the Department of Labor would certify the PERM application, and then you would file what's called an immigrant petition with USCIS. Usually with the H1Bs, they're going to fall into one of 2 employment categories. They're the second preference, which is for jobs that require a master's degree, and the third preference, which is for jobs that require a bachelor's degree. So usually it's going to be in a EB2 employment-based second preference or EB3 third preference category. For Indians, they are backlogged in both the second and third preference categories typically. So what that means is that there are more applicants than there are visas available for Indians in the second and third preference categories. And why that matters is when you get to the adjustment of status phase, you typically will have a wait before you can actually file for an adjustment of status for Indians, and sometimes Chinese will fall into that backlog as well. So after this immigrant petition is filed, you can also file the adjustment of status application once the visa becomes available. Again, for Indians, they're backlogged usually, and that wait is typically several years. It could be more than 10 years before they would actually have a visa available to them to apply for the adjustment of status, where they're able to adjust from a non-immigrant H1B visa to an immigrant visa or the green card. If you're not from India or potentially from China, then usually the visas are immediately available in the second and third preference categories for employment-based applications. And in that case, you could file the immigrant petition along with the adjustment of status application at the same time. And that means that you don't have that big backlog that the Indians do, and you could get your green card pretty much right away. And when I say right away, it's not really right away. Typically, it's several months before the USCIS will review the immigrant petition and approve that and approve the adjustment of status at the same time. Once the adjustment of status application is approved, then you would get the green card in the mail. And previously, during the Trump administration, they were requiring interviews for the adjustment of status applications. I've started to hear from other attorneys that those interviews have been getting waived. And so my guess is, and this is only a guess, the Biden administration will eventually do away with the employment-based interviews because there's really very low instances of fraud, which is the whole reason for having the interviews in the first place. And the employment-based applications typically have very low instances of fraud. And so it's just a waste of resources to have these interviews. So I think the Biden administration will go back to waiving the interviews, but I haven't seen an official announcement yet that they're going to waive those interviews. So until then, you'll have the interview at USCIS and then you'll get the green card. But if they waive this requirement, then you'll just get the green card in the mail. So that's generally how the green card process works if you have an H1B. If you have additional questions, you can feel free to reach out to us. Take care.